Ready? Ready? Ready. Oh. Ladies and gentlemen, welcome. This hearing before the New Britain Township Zoning Hearing Board is called to order. In preparation for our business this evening, I ask everyone in attendance, please silence your cell phones, place them in do not disturb mode, whatever you got to do. And for your information, this, like all township meetings, is now being recorded and shared via virtual meeting. Okay. Some introduction this evening. On my far right, Brian Gaiman, he is our Assistant Zoning and Planning Officer, followed by TJ Walsh, who's a solicitor for the Zoning Hearing Board. Kathy Vasili to my right is a member of the Zoning Hearing Board. Scott Fisher to my left is a member of the Zoning Hearing Board. Our stenographer this evening is Brenda Capiello, and my name is Chuck Coxhead. I'll be holding this meeting. We have some housekeeping to get out of the way here. Folks, the New Britain Township Zoning Hearing Board is a quasi-judicial body required by statute, Commonwealth of Pennsylvania, and created by the New Britain Township Board of Supervisors. This board is chartered with a single responsibility to provide due process to the citizens of New Britain Township to appeal zoning and engineering decisions made by the township. Zoning ordinance was created and is maintained by the New Britain Township Board of Supervisors. This zoning hearing board has no jurisdiction over the contents of the zoning ordinance. We ask that any concerns regarding the contents of the zoning ordinance be directed to the Board of Supervisors. Our procedures for tonight's hearing shall be as follows. This proceeding shall be conducted in a manner similar to that of a court proceeding, and all testimony shall be recorded by our stenographer. All affected parties shall have an opportunity to present factual testimony this evening, and all testimony must be given under oath. Only the facts and testimony presented to the board during this hearing will be considered. The board will first hear the applicant's presentation of their case. The board expects the applicant to state the unnecessary hardship, how the proposal will not be detrimental to the public welfare, and any other grounds the applicant believes support the application. The board will also hear from any other individuals who wish to become parties to this hearing. After the testimony has concluded, the board will hear from anyone who simply wishes to make a statement or ask a question that is relevant to the hearing. Depending on the length of the hearing, the board may or may not make a decision on the application this evening. Our first hearing shall be for property at 19 Skyline Drive. Mr. Gaber, will you please read the public notice and place the application on record?
The application of Daryl and Renee Presti for the property located at 19 Skyline Drive, New Britain Township, Bucks County, Pennsylvania, identified as tax map parcel number 261323. Property is located in the RR Residential Zoning District. The property is improved with a single-family detached residential dwelling, storage shed, in-ground pool, paver deck, and driveway. The applicants seek a variance from New Britain Township Zoning Ordinance Section 27-902B to permit an impervious surface ratio of 29.87% on the property, where the maximum impervious surface ratio permitted by right is 25%.
Thank you, sir. Mr. Wall, exhibits?
They are as follows. Exhibit B1 is the application. Included with the application is a deed dated July 31st, 1995, and a map of property owners that are within 500 feet. Exhibit B2 is a zoning exhibit. It's one sheet prepared by Cowan Associates bearing a date of February 14th, 2023. Exhibit B3 is a letter to the Intelligencer. Exhibit B4 is a public notice for this hearing that was just read into the record. Exhibit B5 is proof that that notice was published in the March 2nd and March 9th, 2023 editions of the Intelligencer. Exhibit B6 is a letter to the applicants and their attorney providing a notice of this hearing. Exhibit B7 is the township list of property owners that are within 500 feet of the property. That is the subject of the application. And together with that list is a map of those properties. Exhibit B8 is an affidavit of mailing that notice of this hearing was mailed to the property owners by the township. On the list on Exhibit B7, that notice was mailed on March 8th by Ryan Gaiman. Exhibit B9 is an affidavit of posting. The notice of this hearing was posted on the property. Notice was posted on March 9th, 2023 at 11:06 a.m. by Ryan Gaiman. And with that affidavit is a photo of the posting. And lastly, Exhibit B10 is the Bucks County floodplain viewer map and aerial of the property.
Thank you, sir. Will you please explain party status?
So who is here for this hearing, other than the applicant and their attorney? Okay, I'm speaking to everybody who just put their hand up. This is a judicial hearing, basically. It's called quasi judicial, which means it's not a town hall, it's run like a court. So not everybody gets to just sort of speak at any topic they choose. It has to be about the application. And there's 3 ways you can involve yourself in this application. 1, you don't have to do anything. You're not obligated to. You can sit and watch and listen and just be quiet. 2, as the chair indicated, when all the evidence has been presented, there'll be what we call like an open forum or a public comment question session. At that time, you'll be allowed to direct a question to the applicant. You can address a question to the board, and you can make a comment yourself. We'll just ask that the comments be germane to this hearing and not repetitive. If you tend to be the 5th or 6th person asking and making the same comment, its probative value by that point is somewhat lost, and we kind of get it. The 3rd way is the most involved way for somebody who's not an applicant to be involved with the application, and that's to be a party status. It would be like if you were a plaintiff or a defendant in a lawsuit. Here, you have to ask for party status. The board has to grant it. In order for you to get party status, you have to be affected by the application. You're affected if you own or live on property that's within a reasonable distance of the property that's the subject of the application. So if you got a letter or the notice in the mail, you're affected. I mean, if you didn't get it, that doesn't mean you're not affected. You just have to make the case. You just have to present why you're affected. Once you're granted party status, you basically will be a party. You get to cross-examine any witness that the applicant puts on, including the applicant if he or she testifies. You get to put on your own application. Your own evidence. You can testify, but you're also subject to cross-examination, as are any witnesses you might want to call. And if you don't like the decision of the hearing, if you don't like the decision that the zoning board renders, because you're a party, then you have a right to appeal that. That's when we say quasi-judicial. It's not just the conduct of how this hearing is run, it's the result. The decision here is appealable. It's not appealable to the supervisors, it goes right to court. And you would have a right to do that if you want to be a party. Okay. Having made that distinction and described those 3 ways, is there anybody who's looking for party status at this time? Okay, seeing none, we can proceed, Mr. Chair.
Thank you so much. Couldn't do without you. Be testifying this evening.
I believe just Mr. Preston.
Okay. Will you be sworn in, please?
Yes.
If you raise your hand, please do swear or affirm testimony about to give the truth, the whole truth, and nothing but the truth.
Yes.
Thank you.
Thank you so much. You can present your case.
Okay, thank you very much. I'd just like to give a brief opening statement just to summarize what is expected as way of testimony tonight. So I represent Daryl Presty and his wife Renee Presty regarding this property that's at 19 Skyline Drive. And what the evidence will establish is, first of all, the property is in the RR zoning district and the maximum impervious surface percentage in that district is 25%. Back in the fall of 2022, Mr. Presty started a project involving the expansion of his patio area, some sidewalk area in the back of the property, and also expansion of the driveway on the property. He contracted with a contractor and was under the belief the contractor would be taking care of things such as permits. Then Mr. Presty had his sister-in-law over about a month after the project started. Sister-in-law is a real estate agent, and she mentioned to him, or asked him, do you have permits for this? And he said, I'm not sure. I would expect the contractor took care of that, but I better check. And his sister-in-law says, well, you better check, because if you go to sell the property and it's not permitted, it's going to be a problem for you. So he asked the contractor advised that he had neglected to obtain permits. So Mr. Presty came into the township, explained the situation, explained that he wanted to bring the property into compliance. And that's primarily why we're here tonight. So the township, of course, said, we need you to submit a zoning permit application for the project. So he did that. It was denied as a result of him being in excess of the 25% impervious surface. And then Mr. Presty went out and obtained the plans that you have before you tonight, which were prepared by the professional land surveyor, Todd Myers at Cowan and Associates. So we're here tonight asking for a variance associated with the impervious surface limit. What Mr. Presty is seeking is 29.87%. He will talk to you about what's on the property currently. I think you already heard that from Mr. Gaiman with respect to the dwelling, the pool, the patio and driveway. What the expansion involved and involves, and then the reasons for that. Now, Mr. Presti understands fully that if the zoning relief is granted, he will need to comply with the township stormwater management ordinance. Obviously, that's going to be the concern if there is one in this particular instance, because we're in excess of the 25% that's permitted there. I would note for the board, this is an undersized, non-conforming property. It is about a half an acre or just under, and your minimum lot size in that district is an acre. This was, I have plans that I will submit to you with respect to the subdivision. It was a subdivision created in 1971. And then, well, actually, I think it was 1970, and his home was built in 1971. So I do have an exhibit packet I'd like to hand out. Would that be appropriate to do so at this time?
Yes, please.
No.
Thank you.
You're welcome.
Sure. Thank you.
You're welcome. Right, and with that, I would like to call Darrell Presti as my first witness. All right, Mr. Presti, you've been sworn, correct?
Yes,
All right. Can you tell the zoning hearing board members where you live?
I live at 19 Skyline Drive, Chalfont, Pennsylvania.
And you and your wife Renee are the owners of 19 Skyline?
Yes,
And who resides at the property?
wife Renee, my daughter Tia, and myself.
When did you purchase the property?
91, July 31st.
I'm going to give you a copy of the exhibit package as well. And I just refer your attention to the first tab, Exhibit A1. Would you agree that Exhibit A1 is the deed for your property?
Yes,
And your property is located in New Britain Township's RR zoning district, is that correct?
that's correct.
With respect to the deed, it indicates, and now I'm referring your attention to the first paragraph in the deed. It references the fact that your particular lot was a lot that was part of a subdivision plan. The subdivision plans dated from 1967, is that correct?
Yes,
And then I'm going to refer your attention to Exhibit A2. You would agree with me that Exhibit A2 is a copy of the plan concerning your subdivision?
yes,
And if you go back to Exhibit A1, your particular lot is listed as lot number 22, is that correct?
correct.
So looking at the plans and looking at lot 22 on there, that appears to be the location and accurate depiction of your property, is that correct?
That's correct.
Okay. This plan, unfortunately, it looks like the exact date on the plan got cut off, but I can represent to the board that the recording date was in 1970. Then I'm going to refer your attention over to Exhibit A3. You would agree this is the Bucks County Board of Assessment summary information concerning your property at 19 Skyline Drive.
Yes.
Okay, so does that indicate about halfway down the first page, the approximate size of your property with respect to acreage?
Yes,
And what does it indicate acreage wise?
0.4936. No less than that.
All right, and then I'm going to refer your attention to page 2 of that exhibit. And about a quarter of the way down, does that indicate the year that your home was built?
Yes,
And what is the indicated date that your home was built?
1971.
As I mentioned in my opening statement, you started a project on the property in the fall of 2022, so this past fall.
Yes,
And can you tell the zoning hearing board members what the project was, what it related to, why you were doing it?
yes. We wanted to increase our patio size some and update the patio, along with the steps going up and out of the pool area. They were getting fatigued and old. And our driveway width, so we could park perpendicular on the driveway to the hill that slants up into our driveway where it's currently noted that the park.
And was there a reason with respect to the driveway expansion and issues concerning your wife?
My wife had a stroke in September of 21. Her right side is weaker. And it's challenging for her to get in and out on the hills, the slope in the driveway.
Okay, so did you hire a contractor to perform this work regarding the patio expansion and the driveway expansion?
We hired a contractor to do the driveway work, the patio work. The driveway is to be done after the patio is completed.
And who was the contractor that you hired?
Portable concrete.
And do you know whether he applied for permits with the township prior to starting the patio expansion project?
I learned after it was started that he did not apply. And when we learned that, we stopped.
Who was it that brought to your attention that you probably should have permits for this project?
My sister-in-law came over, she was looking at what we were doing, we were talking, she's a realtor, and she commented that just in casual conversation, asked if we had gotten a permit, and they recently had their patio done. And I said, well, I'm not sure, I assume so, but the contractor, assume would have taken care of that. So I did call the contractor, and I did check, and he notified me that he did not get a permit, and we stopped that part of the project.
Okay, did you then go to New Britain Township and ask them, how to get the project compliance at that point?
What I did is I came and spoke to first time Ryan and asked about applying for permits. He offered me the opportunity to take the permit applications with me. I told him I wasn't going to do that, and I sent the contractor in for him to do it, and he asked for the permits, the application for the permits and applied.
Okay. After applying for the permit, did you receive a denial or rejection letter from the township concerning the permit that had been submitted?
Yes, we did, because we were over 300 some.
Square feet?
I don't remember the exact amount, but we were over on the impervious ground.
All right. After, having the permit denied, did you then decide to obtain a land surveyor or engineer to take a look at the property to give you feedback concerning the exact amount of impervious surface that you need?
Yes, Todd Myers to come out and survey the property and note the plan that we wanted to submit and what impervious ground we had after the project was done.
So I am going to refer your attention at this point then to Exhibit A4. And taking a look at A4 is that plan that Mr. Myers from Cowan and Associates prepared on your behalf.
Yes,
And he prepared this specifically for purposes of a zoning permit or zoning here, correct?
correct.
And let me just refer your attention to some of the information on there initially. Does the plan list out the minimum required lot area for the RR zoning district in that zoning information that's contained at note 9? And what's the required minimum lot size?
Sorry, but you need glasses.
All right, well, it is the required minimum lot acre is listed as 1 acre for the RR district. And then he listed out your existing lot size as 0.49, which is consistent with the Bucks County Board of Assessment lot area, right?
Yes,
And the required minimum lot width, you would agree, is listed at 150 feet?
Yeah.
And you, the existing lot width here is 100 feet, right?
correct.
And then with respect to your impervious surface, for what we're here for tonight, the maximum impervious surface percentage permitted in the RR district is listed at 25%. Is that correct?
That's correct.
And then let me refer your attention to the next exhibit, and we'll come back to A4 in a few minutes. But I want to refer your attention to the next exhibit and have you describe for the board what that depicts. All right, and if you could turn it sideways. So the area that's labeled as 19 Skyline Drive, first of all, is that your property?
Yes, it is.
And can you orient the zoning hearing board members and advise them what is on the property? I guess, let me step back and ask a different question. When was this aerial taken? Or I should say, is this aerial from a time before you started the project?
Yes, it is.
So looking at the aerial, can you orient the zoning hearing board members and advise them what's on the property prior to you starting the project?
The shed in the back right corner, the swimming pool, and there's a patio deck. And a walkway coming off the patio deck, leading to the stairs or steps to the pool and leading to the little back patio attached to the house. Where a door is to exit in and out of that addition on the back of the house.
Okay, and along the walkway that goes, towards the addition
Mhm.
or along the back of the house, it appears that there are beds or maybe mulch beds on each side of the walkway. Is that correct?
Small beds, yes, on each side of the walkway.
And then if we can have your attention brought back to the exhibit that Mr. Myers prepared for you, which is A4 for the record. Can you describe for the zoning hearing board member what the proposed expansion of the patio is? And just walk them through the additional impervious surface that has either been installed and or is proposed.
And no structure. We eliminated the two small beds that are on each side of the paver walkway. And we eliminated a bed in the back side of the house that was up against the house. And we proposing to turn that all into patio and an extension off of the back of the patio. Small extension, I should say, where next to the right of the steps would also become patio.
Okay, and then you had discussed earlier expansion of the driveway too, is that correct?
Correct.
Can you describe what that involves?
That involves, there was a bed that ran a little island bed, I would call it. That
Do
was
you want to point
between,
that out on exhibit A5 for the zoning hearing board member?
yes, that bed is between the two cars that are parked going up the slope of the driveway to the right of it and the walkway that's leading into the back. What we're proposing to do is to take out the driveway parking spots and turn the cars and park perpendicular to the slope.
And is that the area that would assist your wife with respect to getting out of her vehicle? Or getting out the passenger side of the vehicle?
Yes, yes. She could park more on a flat surface if we did that and not on a vertically into the incline.
And so while we're talking about slopes at this point, generally, what is the slope of the property? Or does it have slope?
Yes, it slopes from basically 3 to 4 houses up from mine. There's a gradual slope that heads towards Deer Path and towards Skyline Drive.
Okay, so on this picture, if we're looking at your house, it would be to the right-hand side or to the driveway side of your property.
Correct.
And so with respect to the new impervious surface that's been installed and the additional proposed for the driveway that has not yet been completed, what is the total amount of impervious that you are proposing? Is that on Mr.
I think it's 29.58.
Point, I think it's 29.87.
87.
Does that sound right?
Yes.
So you have one additional exhibit that we want to point out for the zoning hearing board member, so I'll refer your attention to exhibit A6. describe for the zoning hearing board members what exhibit A6 is?
Renee is treated by Moss Rehab in Jefferson, still undergoes treatment and therapy. They were kind enough to supply a letter to explain Renee's situation, and we're not parking in the store to be supported for her getting in and out of the vehicle.
Do you have any existing stormwater management problems or issues on your property?
I do
No pooling or ponding of stormwater currently?
no,
And you understand that you will have to comply with the New Britain Township Stormwater Management Ordinance if relief were to be granted concerning this application, right?
yes, I do.
And that would mean you'd have to submit a stormwater management plan. You understand that?
Yes,
And you may have to install facilities associated with stormwater management if you were to get this relief. Do you understand that?
yes,
And you're willing to do that, correct?
yes,
And Mr. Myers talked to you a little bit about that, correct?
correct.
And in fact, if you, again, referring your attention back to the plan that he prepared, which is exhibit A4. He actually proposed a rain garden on the eastern side or eastern corner of the property. Is that correct?
That is correct.
But it would be up to the township engineer review as to what stormwater facilities or best management practices you would have to install. Once you submit the stormwater plan. Do you understand that?
Yes, I do.
Have you spoken to your neighbors about the project and the proposal
Yes, I have.
and the additional proposed impervious for the driveway?
Yes, I do.
And did any of your neighbors express that they are objecting or have an issue with what you're proposing?
No,
Do you feel that the additional impervious surface will cause any detriment to your neighbors in any way?
no, I don't.
Do you feel that it will modify or change the character of the neighborhood in any way?
No,
I don't have any additional questions at this time. I would ask the board to take judicial notice of when your initial zoning ordinance was adopted. I think that was in 1995. If my research was correct, that doesn't sound right, Mr. Wall.
Initials in there?
Yeah,
By 1952,
the New Britain Township. 19
when those RR regulations came
Yeah.
out. You can take notice of the fact that you have an undersized lot, so that's fine.
That's all we're looking for.
Thank you.
And I would move to the admission of exhibits A1 through A6 at this time.
So, Mr. Presti, how far along is your project?
I'd have to say roughly about 50%.
And being 50% completed or 50% incomplete, is it possible that you could modify or change the design to come to compliance some way?
I would say if necessary, yes. It would some removal of concrete, but yes.
Could you show us on the map piece where the proposed rain garden would be? You know, in the
You have to go to drawing that surveyor did. And if you look to
oh,
the right side. Where you see
I
that
see it.
they put a rain garden.
Yeah.
The location
Front of the
could be
shed.
wherever the township would like it to be.
Understand that you're not an engineer. Is your inference that the proposed rain garden would potentially bring the property into compliance?
That's the intention.
Thank you.
The driveway. It's not getting any closer to the only change. Is filling in the area. To the left of what I'm referring to as the turnaround space or the extra space.
Intention was. That side of the property. So it's okay if I go.
But that hasn't occurred.
None of the driveway work is.
But the only impervious that you're including in this plan is the squaring off of the end, right? You're not including the going into the eastern side to take it to the lot line.
In this drawing, it should be taking it to the actual lot line. It's about a 2 foot, 1.5 to 2 feet. And it's only for the section where the, I guess the width of the garage.
Well, let's clarify one thing. Your relief is premised upon a definitive plan. And if you're saying something should be on this plan, but it's not, okay,
My understanding that was on the plan.
Okay.
If it's not on the plan, we could skip it.
well, hold on, I'm not
All right.
asking you or Mr. McNair for relief, I'm just explaining the number. Square footage you're asking for impervious is 6,377 square feet. How you divide that up needs to be consistent with the plan, and you're showing those two areas. So perhaps the engineer, when they overlaid the driveway location on the lot, they might have just not put the line. You know, engineers are known to make mistakes when they graph things, so that he may actually have accounted for it in the square footage, he may not. And I'm like saying, okay, that's fine. If that's not there, then your number is going to be lower. Your 9,300, I'm sorry, 6,377 square feet is going to be short. You follow me?
Yes.
Okay.
Did you make Mr. Myers aware of the fact that proposing to widen the driveway in that location towards the eastern lot line?
The gentleman who came out, that works for Mr. Myers, I walked him around and showed him what we wanted to do.
So that the question relates to whether or not you showed him that specific issue of widening the driveway out to the lot line.
I showed him widening it to our fence. Yes,
Fence, do you-
currently it's a foot rail fence.
That's along the common lot line with,
It's shared with my neighbor. It
sorry,
it runs down it's fence is in my whole backyard. It's foot rail fence.
the gentleman's name is just blurred on my plan. I can't read, I know it's, I can see it starts with.
Sign off.
Yeah, I
It's Vlad. So he's present.
Vlad, okay.
He's present.
Oh, okay, I'm sorry, sir, I can't, where's Vlad? Oh, it's not your fault, it's the engineer. You just blurred your name horribly. Yeah, I can see Vlad.
Clearly, because when you said the tax parcel, I see his face.
Okay, so to bring this to conclusion, your square footage is what's going to drive the relief, that drives the rates. So if that was done by your engineer calculating to expand the driveway in those two areas, now you're talking about squaring off the end and just adding a foot to the property line, then you're fine, because there just might be, like I said, a drafting, not error, but just sloppy. As far as the lines, as far as the picture is concerned, not the square footage. But if the square footage is short, you're gonna have to go with the square footage that your engineer gives you, because that's tied back to the definitive plan.
Interesting.
I'd also like to bring up the fact that there's a driveway setback that might to amend the application. First into that driveway setback.
Further, right,
Already there, right?
right. If you don't take it further to the property line, and we don't know this, we know there's like there are driveway setbacks, depending on the type of project. If you were to take it into your lot, you might not have a setback issue. But if you were to push it further into a setback from the lot line, like you got to be 2 feet off the lot line. Right.
It's
Five
to your call, if there's anything related to the property record and related to.
I want to say
driveway
5 feet.
setback.
I remember it being 5 feet.
Hmm.
We have a driveway setback. So if you're closer than 5 feet already, you're non-conforming. And if you want to take it closer, Ms. Vasili's point, you need additional relief.
Was there anything- But
What's that
was there anything with file that you're aware of?
about?
about encroachment in the setback and driveway for the property.
Oh, I would think it's.
About it being an existing
Yeah.
non-conforming, not that I'm aware of, but I didn't particularly look for it.
It's fine.
The driveway, and how it is, was like that when I moved in 1995.
If you're looking to expand closer to the lot, line, right? If you're increasing the non-conforming nature of the driveway, you would need relief to do that. So if you're expanding towards the lot line on the eastern side of the property, you might need, is that, you know, Mr. Walsh, if that's zoning or saldo?
It's zoning.
Pretty sure it's,
I have it here.
we don't get it often. But
Right.
It sounds like something we
But-
were
but we-
prior.
when we get it here, it's a saldo requirement. It would only come in through the back door and.
Right,
Ray would
So you
deal
would
with
not
it,
have
so-
seen it.
So we wouldn't have seen it. I'll let you confer with your attorney on that, but my main point is that the square footage, it's the driving, not figure.
Understood.
Also, do you have any records that might indicate before you started any of the work, or your contractor started any of the work, what your ratio was?
I don't have any surveys that would support what the ratio was.
Okay.
I have pictures and images of what was there.
Well,
No.
we have the photo that's been admitted or is part of the
Well,
record, but
Right,
don't
but
have
my
a-
point is, at 25%, your lot is 21,500 square feet, give or take. At 25%, you're allowed 5,375 square feet by right. Okay, if you were already over that number, just say you were at 6,000, then you're already non-conforming. Okay, and you probably don't have a stormwater facility on your property that handled anything, judging from the age of this subdivision. They didn't care about stormwater back in 1972. It was get it in and get it out. You know, I see you have a drainage easement in the back, but that probably just sheet flows there. There's probably nothing controlling that. It just runs off to the back. So if you were over that 25% by whatever was there when you bought it, and if you didn't do anything, that's non-conforming. Okay, that's allowed to exist. Once you start going higher, which is what you're doing now, that's where the stormwater gets triggered. The engineer may say, okay, we not only want you to deal with the new stuff you're putting on today, the parts between the 5375 and the 6377, you know, the extra 1,000 square feet there, but all that other excess that would have been over the 5,300, that was just there. Because now you're trying to fix everything, if you follow.
and that was something that we did discuss with Mr. Myers already,
Okay.
that the potential exists for that.
So the chair's point was, are you willing to make it compliant? That means, are you willing to put in a facility that would actually infiltrate or control the amount of water as if you only had 25%?
Yes,
And that means like you have a de facto ratio, like you're not over because you're controlling everything that's running off as a result of all that excess.
yes.
And that's, okay, so I'm hearing you say, if I'm hearing you say yes, then that's, yeah, you've had this explained to you and you're on the, if that's just what I want to hear, wanted your response for the record. So thank you.
And to be clear, we're not holding you to that. It's not our place to hold you to that. We're not saying it's going to be that. We're saying you're coming in here and you're testifying under oath. What is your inference based on discussions you had, and what is your intentions in terms
But that's-
of making the property right?
But that's not 100% accurate, Chuck, in the sense that that's what they may require him to do. It's
They may.
design it
That's
to
his intention.
25%. Or the board can attach a condition, say, look, if they're gonna make you do the design it, so it's a 20, de facto 25% ratio, because you're ready to put that in, they can do that. The board can attach a condition here.
Yeah, my only point is, we're not saying what the rain garden specifications they're gonna be. We're not saying that. We have no, it's above our pay grade.
There's many ways
Yeah.
to skin the stormwater runoff
Yeah.
cat. You could put a rain garden in, you
Yeah.
could put some kind of underground facility, you could put plantings. You get credit for planting. There's that, yes, I misheard.
No, it's all right. No, you're right. I
Right.
appreciate clarification. You know that.
But the ratio will be a condition that the board typically attaches to any impervious surface relief, is that you're facilities be designed so it's as if you're controlling water, controlling runoff, so you had a compliant ratio.
Understood.
Okay.
Any other questions? You have anything further?
I have no additional evidence.
Excellent, thank you.
Okay, thank you very much.
Thank you.
Now would be the time, folks. As we have no other parties to the case, if you wish to ask a question based on what you've heard tonight, or wish to make a public comment, you may do so. It's that if you choose to do so, just make sure that we can get your name and your address for the record. Anyone?
Schaefer, 21 Skyline Drive.
Spell Schaefer for us?
Sure. Like the beer, SCHAEFER.
You are dating yourself.
I would.
Support. It's all the confidence in the world in what he has been. It's very upset.
Thank you. Thank you for coming.
Yes, sir.
Get ready for this. Spiro Medusis,
Brenda? Have it.
GOUZO. 45 Skyline. As far as what Daryl's doing, I know he's gonna do it right. I know he's gonna do whatever he has to do to get it right. And as far as I'm concerned, it's gonna improve the value of the properties. So why not? Why not do it? To make my house worth more money, so. Keep on doing it. And I'm not opposed to anything.
Thank you.
And Vlad Maximo,
If we have strong enough glasses, this facility is capable of reading, I'm not. You get it.
so it's this project. No, it's gonna be, where's the order of the
Thank you.
Thank you all, appreciate it.
Thank you, guys.
All right.
Thank
Go off the
you.
record.
Yep.
One sec. You don't go yet. Just gonna go off the record for a sec.
No more than that. Zoning hearing board has completed our deliberations for this evening's case. Do I have a motion?
For any requirements for the stormwater management. As agreed by the applicant and the property owner.
Do I have a second?
Second.
All those in favor?
Aye.
Aye.
Okay.
Thank you very much.
You'll get a written decision within 45 days of today, and your attorney can explain to you what you can do in between.
Okay,
Good
thank you
luck.
very much.
Good luck with your project.
Appreciate the support.
And
Thank you.
thank you for your diligence and, executing, doing what you did the way you did it. It matters.
The right way to do.
And that's why I'm saying thank
you.
you. I'm sorry you're going through this.
Appreciate it.
Thank you all. Nick, highlighting the coming.
Thank you very much, Aaron.
Thank you.
Thank you for coming.
Thanks.
Right, you know, to the booklet,
How's that? We'll throw this under the closet. Or the moto. That's the way you get it. I'll be moto, you nice fun on.
It's a rarity when all the neighbors fill up and they're all supported.
Yeah, right? Never. I confess, when I saw all the cars, I worried a little.
Yeah, I thought so
Thank you.
too, but when they all show up and there was a big love fest, and that's never happens.
Thank you. Yeah, thank you. Is there a different requirement in each zoning? If you just go
big commercial signage is bound by.
by this standard.
Leather bound.
We'll propose leather for the next.
Are you experiencing?
All right, so I'll get serious here. So. Punch. Okay. Our next hearing will be for the property of 4275 County Line Road. Mr. Gaiman, will you please read the public notice and place the application on record?
The application of Blair Image Elements, agent for ERP New Britain Property Owner LP for the property located at 4275 County Line Road, New Britain Township, Bucks County, Pennsylvania, identified as tax map parcel numbers 265492. Property is located in the C2 Commercial Zoning District. The applicant conducts a shopping center use J24 on the property. The applicant proposes to replace 4 existing wall signs, install 2 new wall signs, and retain 1 existing wall sign for a total of 7 wall signs in connection with the giant retail supermarket sub-use. The applicant seeks variances from the following sections of the zoning ordinance. A, from 27-2610D1 to permit 7 wall signs on the building containing the giant supermarket, where the maximum number of permitted wall signs on all the buildings in the shopping center is 5. B, from 27-2610D3D to permit the total sign area of all the giant related wall signs to be 209.58 square feet, where the maximum total sign area of all wall signs on the property is 100 square feet. C, from section 27-2611.D.3A to permit 7 wall signs for a single tenant unit within the shopping center, where the maximum number of wall signs per single tenant is 1. And D, from section 27-2611.D.3B to permit 2 wall signs that contain wording other than the primary tenant's name or logo.
Very good. So,
Well, before I do that, I just want, there was a typo My error. We had a reference that the maximum number of permitted wall signs on all the buildings in the shopping center is 5. It's actually, it should be 2 max, but there are 5 existing wall signs on, at least for this use. The board exhibits, B1 is the application. With the application was an addendum, D dated February 14th, 2006. Letter of authorization from the applicant to their agent, and a list of property owners within 500 feet. Exhibit B3 is a signage packet. It's 23 pages prepared by Glare Image Elements. Exhibit B3 is a letter to the intelligencer forwarding public notice. Exhibit B4 is the public notice. Exhibit B5 is proof that the notice was advertised in March 2nd and March 9th editions of the intelligencer. Exhibit B6 is a letter to the applicants and their attorney providing them notice of this hearing. Exhibit B7 is a township list of property owners of record within 500 feet of this property, a map showing those lots. Exhibit B8 is an affidavit of mailing. The notice of this hearing was mailed to the property owners on Exhibit B7. That notice was mailed on March 8th by Ryan Gaiman. Exhibit B9 is an affidavit of posting. The notice of this hearing was posted on the property on March 9, 2023 at 11:20 a.m. by Ryan Gaiman. Attached to that affidavit is a photo of the actual posting. Lastly, Exhibit B10 is the Bucks County floodplain viewer map and aerial of the lot. I will note for the record, there is no one in the room other than the applicant and their counsel, so I can dispense with the description of party status, public comment, etc.
Thank you very much. Floor is yours.
Good evening. My name is Zachary Severson. I'm an attorney with Eastburn and Gray. I'm here tonight on behalf of Glare Image Elements as an agent for the property owner ERP News Written Property Owners LP. I won't necessarily get into the nitty-gritty, but I'll give you a broad overview of what we're proposing here. This is for the New Britain Village Square Shopping Center. The anchor giant grocery store that is currently in the plaza has 5 existing signs. Essentially, Giant is doing a very slight rebrand. And so they're going in and they're replacing their existing signage. And they're looking to add 2 additional signs. One is for a Giant Direct. It'll go over one of the entrances that alerts people of that the Giant Direct service is available. And then another sign is for beer and wine. The overall square footage of signage for the Giant use is that there's a net decrease in the amount of signage, the amount of square footage in signage. It's going from 217.46 square feet to 209.58 square feet. So there's about 8 square feet being reduced, even though we're adding 2 new signs. So some of those existing signs are being shrunk slightly by a few feet here and there. So really the variance is to go from, the first one is to go from 5 wall signs to 7 wall signs. The second variance is to allow for 209 square feet where 100 is required, but we're already at 217. So essentially that condition is being made more compliant because we're coming close to that 100 square feet. And then the third one is, again, goes to the number of signs. 7 total are being permitted where that section only allows for 1. And 2 of the signs are not just the logo and the branding for Giant. It's the food, it's the pharmacy, it's the beer and wine, those additional features. And I will note that the 2 new signs are both facing into the parking lot. We're not putting any new signage out there that's looking directly out at other neighboring properties. They're all facing into the parking lot, into the parking area where customers are coming in and they're directed to people that are already using the shopping center. I've handed out an exhibit booklet. I would ask that it be, I would think maybe marked as exhibit A1 through A5, if that's suitable for the solicitor.
Yes.
First exhibit A1 would be the deed to the property. The second exhibit A2 would be the authorization letter. These are all also included in your application. We included them here just to make sure that they were present when they were submitted. A3 is an aerial photograph of the property. It's giving some context to the board. A4 is a fact sheet that kind of gives an overview of the tenants within the shopping center. And A5 is our sign package that shows exactly the measurements of the sign and where they'll be located on the property. I have one witness to present this evening, Matthew Clift. And if he could be sworn at this time.
Sir, would you raise your hand, please? Do you swear or affirm the testimony that you give the truth, the whole truth, and nothing but
And I would just.
Please spell your name for the records.
Matt Cliff, CLIFT.
And I would just note exhibit tab 1 and tab 2, A1 and A2. I would just ask that the board recognize that we have standing in the application based on those two exhibits.
We wouldn't be here otherwise.
Still recognized.
Based on the lack of any other members of the public, I am prepared to present an offer of proof to the board if you'd like me to proceed in that way. Otherwise, I can walk Mr. Cliff through his testimony. All right. Matthew Cliff would testify that he is the president of MRC Signs, which is a local commercial sign installation, service, and build work company, and that he has worked in this capacity since 2009. He would testify that his company works in conjunction with Blair Image Elements, which is a sign design company that prepared the sign drawing package that's included as tab 5, which is exhibit A5 in the exhibit booklet, and which company is the national signage consultant for giant food stores. Mr. Cliff would testify that he assists in obtaining municipal approvals for commercial signage for businesses throughout the Northeast, including giant food stores, and that he has testified in this capacity before zoning hearing boards, including in Horsham Township and Newtown Township. With regard to this project, Mr. Cliff would testify that he is engaged by Blair Image Elements to assist in reviewing the township ordinances regarding sign regulations, to visit the site, to travel the township, and to view other giant food stores in the area, and view other commercial building signage in the area. He would further testify that he reviewed the aerial photograph, the New Britain Township fact sheet brochure, and the sign drawings package that are at tab 3, 4, and 5, which are exhibits A3, A4, and A5, respectively, of our exhibit booklet. Using these exhibits, Mr. Clift would testify that the property is over 21 acres in area, is located at the corner of County Line Road and Butler Avenue. It is improved with 143,716 square feet shopping center with 29 business tenancies and associated parking, lighting, landscaping, and signage. Mr. Clift would testify that the giant food store portion of the shopping center sits back basically 900 feet from County Line Road, comprises 57,951 square feet in area, and has a front building facade length of 353 feet. Mr. Clift would further testify that the giant food store has existing signage that is non-conforming as to the number of wall signs. It has 2 permitted where 5 are existing. Size of individual wall signs, which are required to be a maximum of 30 square feet. And total sign area, which is 100 square feet, is permitted, and we are existing of 217.46 square feet. Using the sign drawings at tab 5, exhibit A5 of the exhibit booklet, Mr. Clift would testify that the existing signs are a quote, giant sign on front building facade that measures 50.35 square feet. A giant sign on the side building facade facing Butler Avenue that is 86.84 square feet. A pharmacy sign on the front of the building that is 47.94 square feet. A Starbucks coffee sign on the front building facade that is 20.17 square feet. And a Citizens Bank sign on the front building facade that is 12.16 square feet. Mr. Cliff would testify that Giant Food Store is undergoing a rebranding, which is slightly changing the look of the giant signs as shown in the sign drawings, comparisons of existing and proposed giant signage, and is adding new signage to existing stores to notify customers of its giant direct online order and delivery service, and to notify customers that Giant now sells beer and wine. Accordingly, Giant proposes replacement of existing signage and 2 new additional signs as follows. A giant wall sign that measures 44.88 square feet, which is a decrease in the size of the existing sign by 5.47 square feet. A giant wall sign that is 70.08 square feet, which is a decrease in the size of the existing sign by 16.76 square feet. A pharmacy wall sign that is 22.41 square feet, which is a decrease in the size of the existing sign by 25.53 square feet. A Starbucks wall sign that is 20.42 square feet, which is only a 0.26 square foot increase from the existing Starbucks sign. And then 2 new signs, a giant direct sign, wall sign that is 9.48 square feet that is located on the front building facade facing the parking lot. And a beer and wine wall sign that is 23.6 square feet that is also located on the front building facade. The existing 12.16 square foot Citizens Bank sign will remain as is. Mr. Cliff would further testify that this is a standard sign package for a 57,951 square foot giant food store and is necessary for rebranding and identification purposes. That the existing non-conforming signage is being brought into closer conformity with the zoning ordinance requirements relating to individual sign size and total sign square footage. That the proposed signage is consistent with the commercial signage in the area and other giant food stores in the area. And that the proposed signage is appropriate in scale in relation to the size of the building and in relation to the size and configuration of the property and the significant setback from County Line Road. The 2 new signs are necessary to notify customers of the availability of online order and delivery services and of the sale of beer and wine. Mr. Click would testify that the total number of signs and the sign square footage is necessary to enable the reasonable use of the property due to the site conditions as previously testified to, that the hardship has not been created by the applicant, that the variances, if granted, will not alter the essential character of the neighborhood, nor substantially impair the appropriate use or development of adjacent property, nor be detrimental to the public welfare because the property is located in a commercial district on heavily traveled County Line Road and Butler Avenue, and that the proposed signs are consistent with the signage at other commercial properties in the area, and that the variances are the minimum necessary to afford relief and require the least modification possible of the regulations at issue. All right, Mr. Cliff. Were you present for and listened to my offer of proof of your testimony this evening?
Yes,
And you affirm that if you testified to the board tonight, you would testify consistent with what my offer of proof was? You adopt this testimony as if it were your own?
I do.
And would you make any changes or additions to the offer of proof?
I would not.
I have no further questions. And I would turn it over to the board for any questions.
Thank you.
I just have one question. There's one of the pages, Mr. Cook says the existing Starbucks and Citizens Bank signage to remain as is, but I thought I saw the Starbucks was changed.
It is. Starbucks is, the existing Starbucks is gonna get removed.
Okay.
And the new channel is proposed.
So
The Citizens is staying.
the scope of work page is incorrect, and when it says it's, I don't know which page it is, it's halfway through. The one that says pharmacy on it, but it was scope, I think it's S5. Well, they're all S5. Actually, they also, a lot of them say that now I see it, but this is the page I saw it on. It says
I see where you're talking about. That is an error.
Okay.
The Starbucks is going to get removed.
Okay. Just want to be clear.
That's consistent with your testimony.
Just so the signage is already done.
Correct. We're already in several characteristics. It's all.
So, no, there's been, or maybe Mr. Gainer, was there a previous relief for the signs?
No,
There was a prior decision on signage, but it was for the pylon signs in this application about 8 years ago. had nothing to do with these signs, so it's, to the best of our knowledge, the sign ordinance has changed since these were installed.
What were the other sign keys?
I did not know, they were just the pylons.
Unfortunately, I don't know the answer to that. So,
Well, I think the implication is we have no reason to believe they're not, that any relief was granted, so they're
Right.
non-conforming.
In testimony, if I recall properly, it was stated that all of the sign was going to be done was that facing the parking lot, but in the package, there is one on the side.
there's one, yeah, there's one side.
The one facing Butler Ave.
The one sign.
Oh, okay, so the additional signs are in facing, okay, and then, but there will be a replacement on the Butler Avenue facing side, got it. Okay, got it, thank you.
When is the anticipated placement of this?
Once, if the board allows, for 6 weeks, the final written approval, so anytime after that.
And I'm assuming this is something that all Giants within,
I've done numerous of them, all around the area, Southampton. Ferguson just went for a variance a few weeks ago. They had variance relief signs that needed to get approved. I've been all over.
And any new giants are getting installed as this sign, so the one
Yeah.
one in Richboro, the one in Doylestown.
I did both,
Okay.
yeah.
So,
And it's merely the belief
yeah,
that they're on statements.
Geez, now.
I wish the leaf were green.
That leaf
Sorry,
probably-
drew short straw.
I have no say in the color.
That leaf probably cost a lot of money.
Would if it were green.
I would say just the
The
design.
trees now stand alone as.
Anything else?
Yeah, the NFP were always a fair service because it's all one face and they always crack, so they probably get away with that as well.
Right. It's an improvement to the town. Anything else? Really? Off the record. Do I have a motion?
as
Do I have a second?
Second.
All those in favor? Aye.
Okay, you have relief as requested. You'll get a written decision within 45 days of today, and Mr. Silverton can explain to you guys exactly what that means.
Great,
Good luck with the plan.
appreciate it.
I
Thank
wish that, may this be your last hearing.
you. I doubt it will be.
Thank you.
I'll see the second half. I got, that's a great one to check. Well, they're not getting killed. They're losing